EU politicians and Brexit negotiators alike are furious with the UK over moves to potentially break international law, something the bloc has openly admitted to doing itself before, while arguing justification and innocence. On Monday, the House of Commons voted on a controversial new bill published by the government. The UK is currently in a transition period that keeps it bound to the EU's rules until the 31st of December. The two sides are trying to negotiate a new trade deal that would come into effect once this period ends, but talks have been characterized by perpetual deadlock. With the new internal market bill, the government is essentially seeking to prevent disruption to trade between the four nations of the UK if no deal is reached with the EU. Downing Street has described it as a vital legal safety net. However, the move has enraged the EU and prompted a fresh rebellion within the Conservative Party. European Commission President Ursula von der Leyen has set Prime Minister Boris Johnson a 3-week deadline to ditch his plans or face financial and trade sanctions, with the clear suggestion that negotiations over a future relationship will fail unless the most contentious parts of the proposed legislation are removed. While it is true that if Mr. Johnson went ahead with his plan, Britain would essentially break international law, unearthed reports prove the EU has done exactly that in the past, while arguing its innocence. Professor of International History at the London School of Economics, LSE, Alan Sked recently made an example of this. He wrote on Twitter, "The European Court of Justice ruled in the Cardi Barracut case that the EU should ignore the UN Charter, the highest source of international law, if it conflicted with the EU's internal constitutional order." Mr. Cardi, a Saudi resident with assets in Sweden, and Al Barakit, a charity for Somali refugees, claimed that his assets being frozen was unlawful. Their property was seized without any court hearing or right of redress or allegation of wrongdoing. The UN Security Council adopted resolutions under Chapter 7 to freeze assets of people and groups associated with the Taliban and Osama bin Laden. The EU adopted regulations to give effect and Sweden had given effect to the regulation. The claimants were named in the resolution and regulation. They claimed the regulation should be annulled under TFEU Article 263 and it was a breach of human rights. In the opinion of Advocate General Maduro, EU law did not need to unconditionally bow to international law, if the consequence could be a violation of basic constitutional principles. In a recent report for The Telegraph, the newspaper's international business editor Ambrose Evans Pritchard echoed Mr. Sked's claims and also cited the Cardi Barracut case. Referring to the International Market Bill, he argued Britain has the right to defend itself against Brussels diplomacy. The prominent journalist wrote, "This is not to say that the EU is the most egregious scofflaw of the Western world, but rather that it picks and chooses when it will be bound by international law like everybody else. It will not sacrifice core interests, and it is surely the UK's core interests that are at stake right now," he concluded. At the end of the day, Europe's refusal to offer its immediate neighbour and security ally even a bare bones Canada trade deal is a hostile posture. The EU could have opted for subtler statecraft, recognizing that Brexit requires a fundamental rethink about the EU's near abroad, a chance to create an outer ring of friendly trading nations that do not wish to be locked into an emerging unitary state. Instead, it has driven the UK further away. Historians will judge this to have been a strategic failure of the First Order. This final squalid slide towards an acrimonious rupture is sad for those of us who love Europe des Patres. But the UK has to defend itself against predatory diplomacy. Deal or no deal,